তোমার ফাইলটা দিন আমার। Which for the state? Who is the answering respondent, madam?
Respondent number 3, Lordship.
Respondent number 3.
DI, concerned DI.
You are appearing.
No, my lord, item number 4, my lord, I am appearing, my lord. My lord,
Item number 3, Lordship.
my lord, 3 is going on.
Being asked by this court, learned advocate appearing on behalf of the writ petitioner submits before this court that the respondent
my lord, this sale, my lord, took place. My lord, there was a proceedings, my lord, under section 14T proceedings.
এখানে উকিলবাবু একটা এই দিলেন না Yes, yes, list of date, I got it. Huh. Then what happened, sir?
There was a proceedings under section 14T3,
Huh.
which was disposed of in the year 1977. The allowing the then Rayat Girindranath Das 20.76 acre land as a retail land. Got it in the first list of dates 25th January 1977. The 14T proceedings was disposed of, allowing the
So after disposal of 14th
Yes,
proceeding,
the
subsequent transfers took place.
yes, yes, Malad.
Very good.
Thereafter, what happened? Thereafter, Malad said the Girindranath died in the year 1994, in the October 1994.
Yes.
Subsequent thereafter, 14th November 1994, a suo motu proceedings, 14T proceedings, again suo motu proceedings was initiated against the Diren Rayat, death, since disease, while that suo motu proceedings of 14T proceedings was disposed of, the then revenue officer
Against whom?
against Girindranath Das, who was the original Rayat, who died on in the year 1994, October 1994.
Very good.
The
So against the Girindranath or Girindranath's legal heirs?
no, against the Girindranath. Without without any notice, nothing else. That I shall prove. The suo motu proceedings was initiated.
Very good. Then what happened?
But then the revenue officer came to a conclusion. The Rayat is a single member family.
So prior to that, I intend to take an information from you that after purchase, whether the petition number 1 and petition number 2 mutated their name.
No. They do not take any step for mutation their name.
Very good.
They are only the enjoying the
Petition
property.
number 1 and 2 are the family members of the Girindranath.
No. They are not the family members. They are outsider.
They are outside.
They are outsider.
Then what happened?
Then the 94 the
Another 14T took place.
took place, and the revenue officer hold the Rayat is a single member family instead of 9-member family, and the
Permitted to hold 8.6 and vested 11 point.
11 point.
Then what happened?
Then that was not known to the heirs of the Girindranath.
Very good.
They the first time came about this said vesting proceedings in the year 2022.
2002. Yes.
2022.
Then
They applied for certified copy of that order, and after obtaining the
challenge the proceeding in LRT.
yes.
Then what happened?
The LRT learned tribunal rejected the proceedings with the on the ground that is belated approach.
Sorry.
That on the ground that is belated approach before the tribunal.
So original way was dismissed.
Yes.
Original way was dismissed.
Yes. They against that way number 881 of 2002 that was dismissed. Against that or dismissal order,
it was dismissed on 14/5/2022.
Yes, sir.
Am I correct? LRTT dismissed the way on 14/5/2022.
As per list of dates, yes.
As per list of dates.
14th
Then what
May
happened?
2002.
Yes. Then
You challenged that order in the division bench.
yes, before this honorable court.
Very good. What was the order?
This honorable court, while dispose of that the writ application, granted leave to the petitioner to since the
WPLRT was disposed of with a leave to file appeal.
appeal before the appellate authority.
Oh, before the appellate authority means the commissioner.
No,
Is the appellate authority.
the section 94
Oh, acha.
54
Section 54 of the Land Reforms Act before the appellate authority is the
The DLR.
district
DLR.
DLR.
Very
with that one on the basis of that leave, an appeal was preferred before the appellate authority.
On 27/11/2006.
Yes,
Then what happened?
that appeal was allowed on 9th September 2009.
Set aside the order of vesting.
Vesting.
Very-
Thus, there is no question of the vesting proceedings. The land which petitioner have purchased, that is their retained land of the original right. Well, we are
No, with that vesting order, with this second vesting order, the land of the writ petitioners were vested.
yes, including that one, since 11 acres already 11 acre vested.
But you say that you do not, you are the outsiders.
I am the outsider. It was the vesting proceedings against the original right,
Since you have not mutated the property.
mutated my land.
Very
That
good.
was
Now, what is your grievance now?
now, I am enjoying that property. All on a sudden, in 2024, September, my property was measured by the state authorities. Then, I inquired, and they didn't give any answer to that. Without obtaining any answer, they only orally says, this is their government land. But then, I approached this honorable court, my lord, the read application, the instant read application filed. Then what on the initial day of hearing, my lord was the Justice Aniruddha Rai, my lord, kindly have a look, my lord, the initial order, where my lord, my contention was it was my retained purchased land, Rayati land. There the state has no authority to measure or enter into the land. My lord, then my lord, without making any compensation or without making any award. Without acquiring or without making any compensation. Since
So, how the writ petitioners have joined?
writ petitioners are the owner. Writ petitioners are the owner and occupier of the by virtue of purchase. We are the
No, the writ petitioner and the writ petitioner number 1 and 2
yes.
have their joint title right title interest.
But we have purchased the land in the year 1980.
No, where is the joinder of cause of action? That I intend to know.
The joinder of cause of action, I am enjoying my property by virtue of registered deed of sale.
Sir, try to understand what I intend to. I'm
Yes.
asking a very core question of law.
Yes.
According to you, petitioner number 1 purchased a portion of the property by a separate deed of by an independent deed of conveyance.
Independent deed of conveyance.
And petitioner number 2 has purchased the property by a separate deed of conveyance. So how there will be a joinder of cause of action?
Since the plot has not been partitioned, that's why they both the petitioner, the plot is a big plot. That has not been partitioned between them.
Where is your pleading to that effect?
नहीं
Where is the pleading to that effect? The petitioner number 1 and 2 are they the are they the joint owner of the property? No.
Yes, both. This plot is the.
Oh, petitioner number 1 purchased the property, a distinct share of the property.
Yes.
By an independent deed of conveyance.
Yes.
Petitioner number 2 purchased another distinct portion of the property by another independent deed of conveyance.
Yes.
Then how there will be a joinder of cause of action? That I intend to know. The basic question of the Code of Civil Procedure.
Since the plot is not partition between them, that's why
Sir, I'm taking.
Yes,
Please take a hypothetical situation.
Yes.
I am a landlord. I have a tenant named X and a tenant against Mr. Y. If I disturb the possession of X, X will file a suit for declaration of injunction. If I disturb the possession of the Y, Y will file a suit for declaration. How X and will join and file a combined suit.
How
this writ petition is maintainable?
X and that maintainability point out not taken.
No, I am raising the point.
Sir,
being a court of law, I have every right to raise the question of maintainability. You satisfy? How this writ petition is maintainable?
Since they are both the petitioners are.
This writ petition is not maintainable.
Both of them they are they
no. Where is the pleading? Where is no pleading is there? Where is the joinder of cause of action?
They are jointly cultivating the land.
No, sir, your oral submission will not serve the purpose.
Yes, I shall.
Where is the pleading?
I shall try to satisfy my lord. The whether that pleading has been one of the.
Because each petitioners have their independent right and interest over the suit property. Sir, I'm giving you two options. One by passing an order, we may withdraw. What do you would like?
Maladi,
I will dismiss your application
Maladi,
on the ground of maintainability.
Maladi, I can Maladi expunge the name of one Maladi.
No, that cannot be.
Maladi, that leave
Take
maybe.
down. I'm for the petition.
Well, this is the petition is before your lordship in the second round of litigation. Your
Give me a second, sir.
yes, sir.
Yes, sir.
Yes, your lordship. This is the second round of litigation. Your petition is before lordship.
Who is the answering this one? State or the NHI?
The state, your lordship.
You please come to your right side so that madam can stand appropriately. Yes.
The issue is before your lordship is that your lordship in the first round of litigation, the petitioner holds a land, your lordship, a converted land of 4 decimal, where a construction is made, your lordship. The total land of the petition in the sake Dag number is 5 decimal of land, but that is recorded Pukur 1 decimal. The construction is over 4 decimal of land, that is the cause of action. Initially, the NHI has given me a notice of that you are encroaching that portion of the land, but that notice has got no details. What is the portion, what is the Dag number, anything on that. In the first round of litigation, the petitioner came before this honorable court, where the state couldn't ascertain whether the claim of the petition is that 1 decimal of land belonging to the petitioner has been acquired, and the petitioner is supposed to pay
But according to you, the petitioner is the riot of how many decimals of land?
total 5 decimal of land.
Total 5 decimal of land.
That is in the record of rights as well.
Total 5 decimal.
Yes, sir. Out of it, 4 decimal, the construction is there.
Construction over
4 decimal of land.
4 decimal.
Initially,
According to the NHI, you have encroached 1 decimal.
according to the state, your lordship. Initially, when an NHA gave me the notice, there was no description what is the encroach area. On the first round of litigation, NHA stated that 320 square feet of the land has been illegally occupied by the petitioner. So the coordinate bench has ordered your lordship for a fresh inquiry, spot verification, and to consider the same. That has been done, your lordship. In 1 day, your lordship, when the first day was fixed for the physical verification, that's on record, they couldn't do anything. They couldn't identify that portion of land because the petitioner is not acquiring or holding that land. So they have shifted the second day, your lordship. They have given me an order that I am an encroacher over there of 1 decimal of land. But the reports which were supposed to be there with that, they have never supplied that to me.
Report means the
physical
report of the jurisdictional BLRO.
The concerned ADMLR was hearing your lordship,
Or
the
the
competent
revenue
authority.
officer.
Yes, the BLRO, the competent authority.
The report which you are referring, that has been prepared by the jurisdictional BLRO or the revenue officer?
The competent authority is the ADMLR, your lordship. He has asked the authority to do that inquiry, your lordship. The order they have supplied it to me. That's a pleading in my writ petition as well. Till date, they have not supplied me that copy, your lordship. What was the finding? Because in 1 day, they couldn't identify.
In the earlier round of litigation, what happened?
Your lordship, the order is there.
Kindly show.
Yes, your lordship. Kindly come to page 59, your lordship. In the earlier round of litigation, there was a direction from the court as well. If the state found me eligible, then they should pay me the compensation as well.
Show me the relevant portion.
Yes, your lordship.
To submit a comprehensive representation.
Yes, page 60.
The director to consider the representation and dispose of the matter within a fortnight from the date of, after giving reasonable opportunity of hearing, the grant of stay of demolition of the structure is not considered at this stage. The portion of the petition has been, the petition shall be entitled to compensation. Yes, what happened thereafter?
Your lordship,
You
they have
submitted the representation.
yeah, the representation has been submitted. That is in the next page, page 62, your lordship.
Page number 62.
Yes, your lordship.
Page number 62 is your representation.
Yes, and page 70 is the order communicated to me.
Give me a second.
Yes, your lordship.
What is the contention of your representation?
Your
What
lordship,
I have stated?
the same, your lordship, as I have stated before, honorable court in the last round of litigation, that 1 decimal of land they are acquiring, and they should pay me for that.
Where from will get that relevant portion?
Yes, your lordship.
The applicant is the owner of the land of 4 decimal.
4 decimal, your lordship.
Very good. The authority never served a notice regarding acquisition of my client, but all of a sudden the authority being the such and such issued a notice of removal of unauthorized national highways একটা বার করে দিন removal of unauthorized occupation of এত 26(2). Very good. According to them, you are the encroacher of in the entire land.
No, 1 decimal of land.
1 decimal.
Now, as per your lordship, if lordship kindly
It is against the compensation has been amount has not been received in respect of the aforesaid from trade collector today. Then what happened?
page 71, your lordship.
Yes, sir.
Yes, now on 25/8/2022, the procedure was done, your lordship. If your lordship kindly comes to the bottom portion of that, your lordship,
Yes.
the CR is put such and such on the last paragraph. On the other hand, representative of the NH authority submitted that a portion of his structure is standing encroaching the land of NH 34, and the very notice was issued for removal of unauthorized encroachment. That is the stand of the NHI. In view of both the above submission, measurement, and demarcation of the suit land, with reference to NH 34 is necessary to adjudicate the issue.
Absolutely.
Hence, the special LO Murshid, BLRO Raghunathganj, and the PD NHI PA Malda requested to cause a joint demarcation and measurement on the spot on 9/9/2022 at 11 onwards. And
The petitioner is also requested to remain present
yes, your
on
lordship.
spot with his private amendment.
Yes, your lordship.
So
Now,
the ADM has fixed the date
yes,
and time.
date and time. And kindly
Yes,
see the next portion, 12/9/2022. The
Hmm.
CR is put with joint measurement report. They had some joint measurement report, but they have not submitted till date. Conducted on 9/9/2022.
CR case record is put up with joint measurement report conducted. It appeared the joint measurement and demarcation would not be completed despite doing the same throughout the day.
Yes, sir. So they couldn't identify 1 decimal of land throughout the day.
Same time is further directed and conclude the said work on 20th September and submit.
Yes.
What happened on 20th September?
The next page, 73, your lordship.
Hmm.
The CR is put up with the report submitted by the team engaged for demarcation and measurement of the land is question.
Huh.
This has never been sub to me till date as well.
Which one?
The report, your lordship, they are relying on 2 reports. On first date, on 12/9/2022, they say there is a report, joint measurement report. So they should have given me that as well, because that should be because the
Be there as may, whatever may be.
yes, your lordship, the court has hold me
The comprehension report and along with the report is submitted. Very good.
yes.
Then what happened?
They have not given me now. The submission of the petition in brief. He is the owner of 0.4 decimal acre of land in plot number 575.
On that day, the report was not handed over to you.
Never has been handed over to me till date as well. They will not be able to show that. There are 2 reports, your lordship. On the first day, they couldn't conduct it.
Very good. Then what happened?
Yes, your lordship. Now that is my claim. Then they say the project director NH 14/12/2000 removal of alleged unauthorized encroachment from his land 26(2). That is a part of the record. And the third prayer was he is entitled to get compensation as per provision of the Act of 2013 in accordance with latest notification and authority. So my submission is that 1 decimal of land which you are acquiring, you should pay me the compensation. Now they are saying, on the other hand, the inquiry report reveals that the instant petitioner has been occupying total 0.53 acres of land by constructing 3-story building thereupon, whereas he is the owner of 0.04 acre of land in the plot. It further reveals that he has erected the building by encroaching about 0.0 acre of extra land, which belongs to a national highway attached to his purchased land, and such highway set up much before the date of purchase of the land. That is their thing. Now come to the next para.
Just a minute.
Yes.
Seeing the drawing of alignment of NH 34 attached to such and such, wherefore there is no new acquisition made in trade of his portion. Yes.
Yes. Now they are saying
New acquisition of in the year
held in the year 2010.
the portion of the land the petitioner.
So, your lordship, the state is holding that there has been no new acquisition now. In 2010, they have acquired 1 decimal of land, your lordship.
And you have encroached that portion
They are saying that. If
as
you-
per their demarcation report.
Yes. Now, if I'm putting this question to myself, if they have acquired 0.1 decimal of land, your lordship, in DAG number 575, it should reflect in their DAG number. NHI is authority. In 2010, we are in 2025. I have brought the entire DAG record, your lordship. There is no portion of land belonging to the NHI. The Moja map also I have brought, Your Lordship. There is no portion of 1 decimal of land in the name of NHI.
Where is your proper deed of conveyance?
Yes, Your Lordship. That is an 8.
That has not been annexed.
No, that has already been annexed.
That question never came, Your Lordship. Why? Because they are saying they are not disputing that, Your Lordship.
No, the authority has found that you are the owner of 4 decimal of land.
Your
So
Lordship,
where is your deed of conveyance?
my deed of conveyance holds I have purchased 4 decimal of land.
Then
And and 1 decimal of land is from my ancestral parent. That is the record of right, their record, not my document, Your Lordship.
have you taken that point in your comprehensive affidavit?
No, Your
Comprehensive representation.
Lordship. Why
That I am the owner of 4 decimal of land, that I have
this, Your
obtained the
Lordship?
1 decimal of
that-
land from my predecessor. So at present I am the owner of 5 decimal land,
Your Lordship.
and on that reason I am is constructed a building on 5 decimal of land. Have you taken that point?
That has been submitted during the hearing, Your Lordship, because the BLR record, they have called the BLR to put the record. The BLR cannot make this better, Your Lordship. The report of the BLR will show that I have 5 decimal of land. And the 4 decimal of land which I purchased, the deed is there, Your Lordship.
Before the authority, in order to appreciate, in order to rather substantiate,
Yes, Your Lordship.
appreciation is not with you. In order to substantiate that you are the owner of 53 decimal of land, I'm sorry, 5 decimal of
5 decimal.
5.5 decimal of land, what document you have relied upon?
The record of rights, Your Lordship, the BLR has brought the
The
record of rights.
record of right is not the document of title, sir.
Your Lordship, the question I'm putting this to myself is not about the title. They are saying, because Your Lordship, out of 5 decimal, 1 is recorded Pukur. And the construction is over 4 decimal of land. And when initially the ADML has asked the BLRO has produced the record, Your Lordship.
So where is the perversity in this order? That I intend to know.
Your Lordship, now they're trying to destroy my 1 decimal of land. They have not paid me compensation. If now what they are saying is there are 2 folds of submission. As per the last order of the court, Your Lordship, the NHI submitted, I have been encroaching 320 square feet of land. That is recorded in the order. Now, if the concerned ADMLR is saying I'm encroaching 1 decimal of land, that is more than 500 square feet. So they should ascertain what is that.
Very good. Yes, madam.
My lord, in this matter, my lord, then maybe the state will be the answering
Yes,
decision.
yes. Mr. Butterbell.
Yes.
Yes, sir.
But the inspection has done jointly, my lord. Can you page 72?
Page
State.
72, page second paragraph.
Page number?
72, second paragraph.
Yes.
But hence, the Special Land Acquisition Officer Murshidabad, BLLR Raghunathpurganj, and the PD NHI Malda are requested to cause a joint demarcation and measurement work on the spot on 9th of September 2022 at 11 onwards and submit a report. The writ petitioner is also requested to remain present on spot with his private army, if necessary, to cooperate the demarcation work. Thereafter, my lord, order dated 12th of September 2021. But may I explain? The CR is put up with joint measurement report conducted on 9th of September 2022. It appeared that joint measurement and demarcation work could not be completed despite doing the same throughout the day. So the same team is further requested to conduct and conclude the said work on 20th of September 2022 and submit report by 23rd of September 2022 positively. Thereafter, my 20th, next page, page 73. On 23rd of September 2022, the matter was taken up for hearing. And may I read, my lord? The CR is put up with a report submitted by the team engaged for demarcation and measurement of the land in question. Seen the report, my lord. Therefore, a report has been prepared. Gone through the comprehensive representation dated 22nd of August 2022, submitted as per direction of the Honorable High Court, issued on 8th of August 2022 in WB number such and such. Submission of the petitioner in brief is as follows, my lord. But he is the owner of 0.04 acres of land in plot number 575 of Mauja, such and such, my lord, district Murshidabad. Second submission, project director NHI Malda had issued a notice on 14th of December 2021 for removal of alleged unauthorized encroachment from his said land under section 26(2) of the Control of National Highways Land Act 2002 without paying any compensation and without issuing any notice for acquisition of his land. And third submission was that he is entitled to get compensation as per the provisions of the Right to Fair Compensation Act 2013 in accordance with the latest notification of NH authority. On the other hand, the inquiry report reveals that The instant petitioner, may I read that? On the other hand, the inquiry report reveals that the instant petitioner has been occupying total 0.053 acres of land by constructing 3-storied building. Thereupon, whereas he is the owner of 0.04 acres of land in the plot.
Take down. That's all.
Number 7. On the last
Press
occasion,
the file first.
on the last occasion, my lord, my
Give me a second, sir.
yes, I'm sorry.
May I file the report in the form of
Just take
video?
down. You have served the advance copy?
Yes, I have served on 15, Lordship, there was delay. On 15th, I have served.
No, report you have served.
Yes, report I have served on
Lord, I
15th.
have received it, but there was some delay. I do not take those.
Very
calls.
good.
But only one thing I would be indicating that having regard.
You want to file exception or? Very good. Say
Exception
like that.
has to be filed, but I just add one rider. In the particular, kindly take.
Sir, file exception I shall hear.
I will, because they are now, they have already filed their particular exception. Kindly.
No,
really
they have
see-
submitted a report. You want to file exception?
I just say this thing, that the main thing which is required to be disclosed in the report in para 8 has not been said.
Very good. It will go in favor of you.
No, I favor with you, but I was just wanting the date when, my lord, this particular thing, when these private contractors have been appointed. Nothing more, nothing less.
Which order? Which is
With
what?
para 8,
Where is the order under challenge?
my lord, the order, my lord, which is the subject matter of challenge, that my lord.
Page number, sir?
Page, that is at page, my lord, it starts from page 88, 13 September 2024. The plea which has been.
Give me a second, sir.
I'm sorry.
Appointed new contract, private contract.
He admitted that this is my land, but at the same time they say that we have given it to a contractor.
Private contract.
And now I say that only this thing, that you give me the date when you have given it. Nothing more.
So according to them, your leased out area, your property forms the part and parcel of the leased out area.
No,
According to them.
according to, no. My lord, your lordships may kindly consider.
No, sir, kindly come to page number 89, sir.
Page
Second
89,
page.
yes, I am at page 89.
After consultation of the aforementioned geo
Yes,
and mining lease deed,
yes.
it is crystal clear that the applied area
Also,
falls within the existing leasehold area of Hatgach.
such a Blackstone.
So lease,
Is given by government. to
you are
the-
led by Mr. Bhattacharya, sir.
It is given by the government to the.
Now, my lord,
corporation.
May I just,
No, according to them, your property, your royalty land falls under the leasehold area,
yes. And now, my lord,
which you are disputing.
and I am submitting further a stage that how can you give contract in respect of my own private land?
That I'm saying. That
You cannot do that.
you have sought for license of quarry from your royalty land.
Right.
They have come to a finding.
I'm extremely grateful.
They are
That
come
is
to a
the
finding that they have leased out the area and your royalty plot falls within that area. You are questioning that.
Yes, I am questioning that even if you have given it to a contractor, kindly give the date when you have given it.
Now,
File an exception because
what is the infirmity prima facie infirmity according in the report?
Millard, I say Millard, this thing I should say that my land is a private land.
So that I am saying.
My land is a
Your
private land.
property say it is your property, the royalty property.
Yes,
They may The others are the vested land or the riverbed or whatever may be.
Yes.
Oh, it is a Blackstone quarry. According to you, your royalty property cannot be part and parcel of a leasehold area. That is the sole
the
content.
only point.
Very good,
Nothing
sir.
more.
How much time will be required to file exception? 3 days?
Tindin?
Action.
He
Sir.
said, go to
No, sir.
Tindin, করে দে ভাই, please করে দে। Yes, yes. Milord, I want that before your lordship goes,
Very good,
Milord,
sir.
your lordship may.
No, if I go, I'll return with the grace of God, sir. No.
After
No, not
fortnight.
I'm sorry in making this particular use of this word.
No, no. I'm very good, sir. The report report in the form of affidavit as filed on behalf of the respondent number 4 and 5 is taken on record. Mr. Bhattacharya, learned senior advocate, appearing on behalf of the petitioner. It happens.
Well.
Once upon a time, I was also a member of the bar.
I petitioned when, or you may recall, I was allotted the land in
Which
2008.
for the petition? Oh, yeah.
I allotted the land in
Give
2000.
me a second. Give me a second, sir.
I mean, default, Milord.
Report day. কি দেবে রিপোর্ট কি বলা আছে কি বলা নেই রিপোর্টে
Nothing বলার আছে। Xerox নেই।
So from Mr. Mitra, from rural to urban. From rural to urban. Very good, sir. Yes.
Well,
Milord, I was to file a report in the form of an affidavit. Your lordship directed on the previous occasion. On 7th of July, your lordship directed so.
So what prevented you, Mr. Chatterjee?
Milord, nothing prevented me, Milord. It is lack of diligence on part of the state, Milord, I'll say. But what the instructions are very sensitive, if may I use
So
that
what is
term.
the good of using my order,
No,
passing
no,
of the
Milord,
order date
we
7 July?
will pray. This is the first time, your lordship will pray for an affidavit, Milord.
No,
in
first order is a no order.
True,
Mr.
Milord, this is
Chatterjee.
a slip of tongue on my
Huh?
part. On the first occasion itself, your lordship directed, Milord.
It's not ready.
No, Milord, but I have got instruction, Milord, the lease deed, they are, by virtue of which they are claiming true, Milord, appears to be a forged one. Milord, their FIR has been drawn against the
Lease deed of a residential plot.
no, 300 katas of a commercial plot, first
that
allotment, then full payment received, then registered lease, then mutation. Which one is forged, let him say,
I do not know.
Then why? Even then the possession was not given.
not given. So now they are saying,
So
which
it
of
is a commercial plot.
commercial plot.
Mr. Chatterjee ought to be very.
I know, Milord, I have told my, kindly give me 7 days of time. I'm sorry, my lord.
Take down. On behalf of the respondent state, Nine, who is appearing?
And I beg to appear for the petitioners, my lord. My lord, pursuant to my lord's order, I have served upon the respondent number 5 and 7, my lord, and also the learned my lord, government pleader, my lord. My affidavit of service, my lord.
देखिए एक बार सर्विसটা দেখি। You are appearing on behalf of the respondent numbers 1 to 6.
My lord. State response.
State response.
Here, my lord, 5 and 6 is the my lord answering respondent, my lord. Subsequently, my lord, with leave of the court, my lord, the private respondent was added as respondent. Since, my lord,
Yes.
my lord, one contiguous honor being the private respondent in this matter, my lord. My lord, he, my lord, submitted a complaint before the PWD department, my lord, alleging that the petitioners, my lord, encroaching, my lord, the PWD land, my lord. On, my lord, due to inaction of the authority, the private respondent preferred no writ petition, and the Honorable High Court, my lord, directed the concerned BLN LRO, my lord, to conduct an, my lord, inspection, spot inquiry, my lord. Pursuant to that order, my lord, the BLN LRO, my lord, conducted inquiry, my lord, and my lord, that inquiry report was submitted before the, my lord, the respondent number 5, my lord, being the assistant engineer, PWD department, my lord. Pursuant to that inquiry report, my lord, the assistant engineer, my lord, conducted hearing, my lord, and without, my lord, providing appropriate opportunity of hearing to the petitioners, my lord, on only solely, my lord, relying on the inquiry report, my lord, the order of encroachment has been passed, my lord. Subsequently, my lord,
Order of encroachment or order for removal of encroachment?
subsequently, one notice was served, my lord, for removal of encroachment.
10-3, 10-2.
10-2, my lord, under 10-2. Now, my lord,
SDO has passed order.
no, my lord, that subsequently, my lord, that entire proceeding
No,
was, my lord,
which order under is under challenge?
my lord, page 23, my lord, kindly have a look.
Where is that?
Page 22 is the, my lord, the physical inspection report of the BLN LRO, my lord. And the relevant portion, my lord, page 23, first paragraph, my lord.
Page number 23.
23, first paragraph, my lord.
Page number 23 is the
report,
inspection report.
my lord, my lord.
No, I want to see where is the order under challenge.
Page 25, my lord.
Page 27 is the notice of encroachment removal, my lord.
25, my lord, order.
That what I am asking and what you are replying. I
Yes.
want to see the
Reason.
order under challenge first.
My lord.
Where is that?
Page 25.
Page
my lord.
25.
My lord, the applicant and defendant are found present at the time of hearing and signed attendance sheet. On behalf of petitioner Sri Satyajit Mandal, son of Sri Chandidas Mandal, is his verbal deposition.
Give me a second.
There's an appealable orders also. That is the appealable orders also.
To the SDO.
Yes, my lord, that my lord, pursuant to that order, my lord, memo, my lord, under dated, my lord, 24th of April 2020.
Give me a second, sir.
The appellant and defendant is found present at the time of hearing, my lord. There's a recording on the order, my lord. Appellant and defendant is found present in that at the time of hearing, signed attendance sheets on behalf of the petitioners, Satyajit Mandal, son of Chandidas Mandal.
My lord, provision direction.
না, আপনি বলছেন যে উইদাউট হিয়ারিং করেছেন আপনি।
না সেটা বলিনি আমি তো।
সেটা প্রথমে বললেন তো।
না আমি বলেছি অ্যাপ্রোপ্রিয়েট অপরচুনিটি। সেটাই Now, my lord. My lord, after that notice was served upon the petitioner, my lord,
I'm sorry. You are challenging the 10-1 notice.
my lord, I am challenging the 10-1 notice as well as, my lord, the inquiry report of the BLN LRO, my lord. Why, my lord, I am challenging the report of the BLN LRO, my lord. In the report of the concerned authority, my lord, there is a finding. Two plots are involved. Plot number 642 and 643, my lord. So, my lord, I crave leave to place, my lord, first the report of the BLN LRO, my lord, where, my lord, the concerned authority specifically, my lord, mentioned that in plot number 643, my lord, there is a dwelling house, my lord, which was constructed 1 year back, my lord. But in the finding portion, my lord, the same authority, my lord, held that there is an encroachment, my lord. So, my lord, may I first place the report of the
এক সেকেন্ড এই ওইটা বার করুন, ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্টের মধ্যে যেটা রয়েছে সেটা বার করুন। ওই যে আমাদের প্রেমিসে না ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্টটা বার করুন, যার মধ্যে ল্যান্ড রিফর্মস এন্ড টেনেন্সি রুলসটা রয়েছে। ওইটা বইটা বার করুন, নতুন বইটা। Yes.
No, my lord. May I place the inspection report of the BLRO, my lord? Once, my lord.
Sir, I'm cautioning you
Lordship,
because you have challenged 10-1 notice,
lordship.
and your basis of challenge is obviously the report of the BLR.
Lordship,
Sir, I'm cautioning you once again
my lord.
that in the event this court holds against you,
Lordship.
it may affect your 10-2,
Yes.
10-3, 10-4 proceedings. You will take that risk. I'm asking.
In that,
No, sir, I'm cautioning you.
oh, your
I'm not
lordship, it
threatening,
will-
I'm cautioning you.
that will cause, my lord, grave loss to the petitioners, my lord.
So
Since,
to-
my lord, they are
We will take that risk because you have challenged 10-1 proceeding
lordship,
on the basis of the BLR report.
my lord.
And if I hold against you,
My lord, there are subsequent event, my lord. The matter was referred.
either as it may,
My lord.
if you are still on that, I
No,
take
no, my lord. If, my lord, in that case, my lord, don't intend to, my lord, to lose the rights of the
then
petitioners, my lord.
you withdraw the writ petition. Whatever. I'm not asking. It
My
is
lord.
your choice.
My lord. Only, my lord, prior to that, may I place only one thing? my lord?
Why should I?
One. Yes.
If I do not, don't waste my judicial hour. If you place, I will not allow you to withdraw.
My lord, kindly appropriate.
You may think for this day also.
Now,
Give
my
you
lord,
the liberty. This much liberty I can give you. I'm making not this mistake.
my lord, I leave to lordship, lordship.
Very good. You want to withdraw?
My lord.
Acha.
My lord, this is my report in the form of affidavit and I have served the copy, my lord.
রিপোর্টটা দিন
তো বলেছে দিয়ে দেবে একটু টাইম লাগবে এই তো ব্যাপার আর কি আছে হ্যাঁ তুমি বলে দাও আমরা তাহলে তুমি এক্সেপশন দেবে কিনা বলো
Yes, sir.
No, my lord, I have gone through the report itself.
You want to file exception?
My lord, extremely grateful to my learned esteemed friend, my lord, that they are accepted, my lord, my claim. Since it is a long years taken, my lord, approaching this court on like that, they want some time to implement this order. If that be so, if my learned friend, my lord, submit that, then I have nothing to submit anything. This is the acquisition of 1979-80. The petitioner approached before this honorable court in 2023, but it appears from the records that the land has been acquired. There has been a requisition, not acquired, requisition, and possession has been taken over. Now, under the my lord,
Under
the
which act? Act 1,
Act 2.
Act 2. Then
They-
2013 will apply.
Yes. 2013 apply or my lord or direct purchase.
No, no, sir. No direct purchase. 2013.
13
Yes,
act,
take down.
he is not, there cannot be any
Ashwin.
direct purchase.
The report has submitted on behalf of
Please, Your Lordship, I am appearing for the petitioner in the matter. There was a direction by Your Lordship that a report has to be filed by the state. My Lord, this is where we are alleging that a plot of land has been, my Lord, acquired. We have not been given payment against it. No compensation given. So, no,
Where is the report? I do not find any report
we
here.
have not been given, my Lord. We have not been served a copy of the report yet. It's been just
Where's
handed.
the report, sir?
It's just been given to us.
Who is the?
I am for the
My Lord.
competent authority, my lord. I was pleased to direct, my lord.
It is for number 5 authority to submit a report in writing on the adjourned day when the incident matter.
My Lord, kindly take up page 3 of the report. I have just been given a copy. My Lord, this is not in compliance with Your Lordship's direction because, my Lord, all that they were, my Lord, required to indicate is the quantum of money which they are ready and willing to give. That would, my Lord, that would decide whether there is a dispute in the matter, whether we are agreeable to this
I'm
or
sorry,
not agreeable.
Mr. Dev, response number 5 is the Kala.
Yes, my lord. That is report filed, my lord, and if your lordship will see paragraph.
Give me a second, sir. Yes, what is your prayer in the writ petition, sir?
But kindly take up, my Lord, page 13. We are pressing for mandamus. My Lord, kindly see page 13.
Yes, sir.
The compensation is what we are praying for, my Lord. That's prayer C. Mandamus directing the respondent, its men agents, employees, and assigns to forthwith compensate the petitioner adequately for 14 feet of land unlawfully acquired. So, my Lord, they say we have acquired it. They've already constructed, my Lord, the road. Now, my Lord, my contention is if you have acquired, then disclose it before the honorable court. What is the compensation that you're willing to give? That is why the report was called for.
Hey,
My Lord, kindly
Nasa.
take up page 3 of the report.
My
There is
lord,
no whisper of the quantum. That's my grievance. So my learned friend is required to, my Lord, file another report by which they disclose the quantum. Page 3 of the report, my Lord.
Give me a second.
My Lord. Only one page, my Lord, page 3. Rest is, my Lord, the annexures. That is, my Lord, may I only indicate along with this page?
Give me
kindly-
a second. Give
My
me a
Lord.
second. Yes.
There are only 2 pages from the writ petition. May I only for recapitulation, my Lord, kindly take up page 30 of the writ petition.
30.
30.
Huh.
This is our letter by which, my Lord, we state our stand and we request, my Lord, the project director and the regional office of NHAI. It's a notice which we state, my Lord, that this is DAG numbers 19 and 20 for the purpose of construction of Bardwan bypass. Third line in paragraph 1, my Lord. Had commenced construction in blatant disregard of the laws of the land. Paragraph 2 at page 31, the first paragraph there, my Lord. Being aggrieved by and dissatisfied with your conduct, our clients had issued a letter addressed to the project director wherein our client had raised their objection with regard to the illegal acts. Further requested you to redress the issue regarding illegal unauthorized acquisition. Paragraph 3, therefore, in
Then
line-
what happened?
Now, my Lord, there's a joint survey which was conducted. That's at page 37. The second paragraph, my Lord, at page 37.
Hmm.
Lord, your Lordship will find that folded because last day, my Lord, while I was submitting, I had indicated this. With reference to the above, it is to note that this office is in receipt of the legal notice from the advocates, wherein it has been requested to conduct the joint survey of plot 1920 Mauza Gopal Nagar as major portion of the land being acquired for construction of Bardwan bypass from the above mentioned plot without the knowledge of the client. That was a grievance. On the basis of that, my Lord, the next page, page 38, a joint inspection, spot inspection was, my Lord, spot inquiry was conducted. Kindly see, my Lord.
You are
serial
present
number-
there.
We were present. And serial number 5, the surveyor was also present.
Josna De.
My Lord.
Josna De was present. on behalf of the
Milord,
applicant.
Jyotsna
Yes.
Se was not there. Milord,
Yeah,
Dulal,
on behalf, representative was present. Surveyor.
serial number 5.
Yes, sir.
Milord, over the page, this is, Milord, where they say the affected area, page 39, 1 and 2. As per the joint inspection report of the affected area, plot 19 and 20 are as follows. They give the details there, Milord.
Huh.
With this,
Affected
we
area
write
of
the
plot
letter.
number, just a minute.
My lord.
Plot number 201050 marked as A color, red shown. Where is A? Is
Milord,
mark
A
B,
is marked here, Milord.
marked A and mark B. Yes.
A and B.
Affected area of plot number 19, mark B.
And mark B.
Very good. Then
Thereafter, we then encapsulate our entire grievance, that's page 40, to all these parties who are now party respondents in the proceeding, Milord. 18 December 2020.
according to the sketch map is faulty.
No, Milord, it is right. That's what we say, that you have acquired, that is not in dispute anymore. You have acquired.
Very
So
good.
with this acquisition, we have not got any compensation. So we file this petition. Before that, there's a letter, demand of justice. I'll indicate that. We file the petition as to what is the compensation they're willing to pay us. That is why, my lord, your lordship had directed them to file a report where, my lord, they would indicate that against this acquisition of plot of land, what is the compensation? Because today, my lord, if we accept the compensation, matter will end. If we do not, then it's a dispute case, my lord.
What is the report?
The report is at page 3, and my lord, there is no quantum there.
No, let me
May
hear.
I only indicate this? I'll complete in 2 minutes, my lord. Can you take a page 40 of the writ petition, my lord? There are two documents. Page 40 is 18 December 2024, top right hand corner, my lord. And this we followed up with another letter, which is at page 45. I'll trouble your lordship only with that page 45, nothing else.
Yes.
That's 14th of February 2025. Can you see the date, my lord, at page 45, top right hand corner? 14th February 2025. Next page, my lord, over the page. Can you see at the bottom, 1, 2, and 3? This is what we sought for, my lord. 1, clarify the status of the compensation process and actions taken so far. Confirm the quantum of compensation and the tentative timelines and the formalities for release of the compensation amount. And 3, release the compensation amount as per the timeline. That was, my lord, our prayer, which was not, my lord, adhered to. They did not reply to this letter. Pursuant there to the writ petition. So, my lord, now kindly take up the report which they have filed. They have acquired
So
that is not in dispute.
Mr. Dev, Kala will take the appropriate step.
The procedure. Now the procedure is this, my lord. Now first we, my lord, demarcate the land and calculate how much the land was encroached by the authority. My lord. Now that is paragraph 4. That was I have indicated page 3, paragraph 4. Now it is the procedure that we must, my lord, started the proceeding of the valuation of that land, my lord, that encroached portion.
It has been extended beyond the land acquired.
That is, and my lord, I have stated in that report that how much land is there, my lord. That is 0.014
0.016 and
0.024.
that is 16 and 24 decimal.
4 decimals.
Huh?
2.6 and 2.4, total 4 decimals.
Now I my lord,
Absolutely,
started
4
the proceeding. Now we started the proceeding for calculation of the valuation. After complete the valuation, my lord, I asked the money from the national highway, and after
May I only
giving
pray for
the
this?
money to the respective.
My lord,
But
kindly
This is the
keep the matter
procedure.
pending. Let them file a report on the valuation. So, my lord, it will be before the honorable court. But once
No,
that
if
comes
you
in-
are agreed with the valuation,
we don't
you
know
have
the
to go.
valuation. My lord, today the difficulty
Sir, the
is,
law is that
My lord.
if you are agreed with the valuation, you have to go before the arbitrator.
I am very grateful. My lord, I am aware of that. My lord, today, if we do not know what is the kind of compensation, my lord, they are offering, my lord, if I'll indicate why. Kindly give me a minute, my lord. The only reason I'm making this submission is this. Today, if the valuation we are aggrieved by, my lord, we have to go before the arbitrator.
I can make it time bound this much. That's not
May I
my
only pray for
very good, sir.
May I only pray for this, my lord.
Time bound.
Very good.
My lord,
Ashok.
I have no
May I only
Bye.
make one submission, my lord, subject to your lordship's kind consideration.
It's not so big matter that you Whatever, maybe I can. Into queue. Who is for the state? You are for the petitioner.
I'm for the petitioner.
State তো দরকার। We are for the private respondents.
For
State is also not present. I believe the private respondents are the answering respondents. It is challenging the order of the tribunal.
That's right.
You have made payment pursuant to my order. Do you know who is the advocate on record of the private respondents?
Munshi Ashik Ilahi.
The order was passed in open court on the last occasion, and
And they also moved a similar application before a coordinate bench of this honorable court. When your lordship's order was cited. But similar prayers. The developer wanted to poke his nose in the proceeding. So the honorable court was pleased to release that order. And in that court, they pressed for hearing of the application and
release that order means
the writ petition.
release the application
That application. As also the writ petition.
without passing any order.
Similar matters, the honorable coordinate bench has been pleased to release the matters since your lordship is taking up similar matter. And the matter has been
I
accepted.
understand.
And what they are they know that this is fixed on 22nd.
No, it was fixed on the I can recollect. It was passed. Let us pass, keep it password for some time. Or I'll make it not today only. You will give a notice. Ashun. Yeah, I understand. I know what is the case. But I am giving a chance to the state to appear. Meanwhile, add one line once more. In the event none appears on behalf of the respondent state on the adjourned day, you may give aspersion to the court,
No, my
not to
lordship,
the
just one more indulgence. Since the matter is being adjourned, I believe one of the workmen has not been served because the respondent has died. The legal heirs, I don't believe, have been served. Let them also serve the legal heirs and come back on the next date so that there's no further adjournment in the matter.
So they have to take out an application.
Huh? Not served date. Respondent number 9, I believe, has died. I believe the heirs need to be served. Kindly allow.
So then they have to make an application.
You substituted then or give the details. No, no, details is substitution হয়ে গেছে খালি তোমরা সার্ভ করোনি কি ওকালতনামা কে দিয়েছে তাহলে তাকে দিয়ে দিচ্ছি ওকালতনামা কেউ দেয়নি Oh, notice was sent, it has come back with the endorsement key. Notice not found. It has come back with the endorsement not found.
দেখি একবার ফাইলটাই কতবার যে নেব না কি জিনিস ফাইলটা দিন ফাইলটা
I'm sorry, I'm just trying to expedite the matter. Then he can. But if Mr. Kaur has the instruction, he can also appear. আমাকে দেয়নি আমাকে ওয়াকালতনামা দেয়নি আমাকে 8 আর 9 দেয়নি কেউ আছে লক্ষণ হালদার অ্যাডভোকেট Oh, but one Mr. Lakhon Chandra Haldar has filed his Okaratnama. I know him, I shall serve a notice on him.
By which order I allowed the application for substitution?
Lordship, it's an order dated 21st November 2024. Your Lordship will find in that order the second page, Roshan Nara.
Give me a second, sir.
I'm sorry, my lord.
November, yes, sir.
Yes, my lord. 21st November 2024, the second page, Roshanara Begum, wife of Shabdin, be incorporated after recording the death of the respondent number 9, Saida Bibi, which is at paragraph 3, page 1.
Learner, we are requested to call service of notice along with the upon the substitute respondent number 9.
He is here, he is here.
Huh?
On job of the added list.
Respondent number 9.
Copy of the writ petition has not been served. বাকি সবাই অ্যাপিয়ার করছেন
You are for the substitute respondent number 9.
Well, the name of the respondent was not correctly recorded. রোশনা রোশনা বেগম রোশনার জায়গায় কি হয়েছে ওটাকে তো উল্টো পাল্টা রয়েছে দেখি রোশনা বেগম
Mr. Roy, you have not filed the affidavit of service upon the substitute respondent number 9.
রিটার্ন হয়েছে
On 21/11/2024, an order was passed to serve notice along with a copy of the instant writ petition upon the substitute respondent number 9, Rosenara Begum, and to file affidavit of service. When such affidavit of service has been filed?
Rosnara Begum name is not correct, my lord. Rosna, Rosna, Rosna Begum. That there is a mistake.
What is the affidavit of service?
Lordship, I will check with that, but Lordship, upon instruction, I submit that the copy of the writ petition along with the application was
Apparently-
নামটা লিখে দিতে
Oh, sorry.
just come back.
Give me a copy.
We shall provide, my lord. Shall provide.
এই রিট পিটিশনটা দিন মুশকিল ভাই ইনস্টলমেন্টে উকিল লোকরা লেলে তো আমার কাজ করা মুশকিল রে ভাই
নামটাই লিখে দিন। ফোন করেই গেছে। এটা কত কাগজে? 1 to 8 তো রাখো। হ্যাঁ 1 to 8 তো রাখো।
1 8 আমি নেই 1 to 3 to 7 and 10
3 to 7 and 10. 7 and 10.
বললেন বাবু এই দেখুন আপনারাও করছেন না কাজ এখানে বললো ডিপার্টমেন্টকে ডাইরেকশন দেওয়া হলো এই সঈদা বিবির নামটা বাদ যাবে তার জায়গায় রোসেনারা বেগমের নাম
I am gratefully, Lordship. I would prefer some precedence because the bank account, the money can be removed. So we only want an injunction.
That I object to, my lord.
Object to what? The workman getting money.
There is division between the work.
The workman getting money, there is a problem.
Some sponsored by developers, some not.
Yes, he has just come. Probably he has got not any appropriate instructions. You mentioned as soon as assignment order is uploaded, I will take it care of.
Trying a level best because of the urgency to have it assigned before your Lordship so that.
I'm ready to take up.
Yes, ma'am.
And if possible, you also inform the state advocate.
Lordship, we shall.
আর এটা একটা ওই এতে পাঠিয়ে দাও এলআর চেম্বারে পাঠিয়ে দাও I am making an endeavor to ensure the appearance of this state advocate.
Yes, my lord. If these applications can also be kept in the
Can it
record,
be
then
served on the office of the learned GP, government pleader? This may probably expedite the process
He will do.
of assignment. Yes. Legal remembrance.
Lordship, should I hand over the WP numbers because they are to be assigned? Very well. I shall mention one.
Assign immediately after assignment, mention the matter in the first sitting of the court. After giving a notice, I shall fix it on that day. Be rest assured.
I'm grateful. Your Lord.
Call the next matter. ভুল হয়ে গেছে ঠিক আছে বাদ দিয়ে দিন 47টা কেটে দিন 47টা ওটা নট টুডে করে দিন wrong listing no very good item number 47 not wrong listing what is scan 1 of 2022
On a restoration application.
আচ্ছা 48 এটা কত হচ্ছে 48
Yes, yes, ma'am.
48 এ তো কোনো ক্যান নেই
One is my lord the restoration application, another is my lord the.
no can is showing
Last occasion the can was there, my lord. On that day, my lord,
এটা নেওয়া যাবে এগো নেওয়া যাবে 48 এ কোনো ক্যান নেই হ্যাঁ
on 14th.
এখানে শো করছে না তাতে কিছু অসুবিধা হবে না
In person.
তুমি লেখনি নাকি লেখো ক্যান বললি ওখানে কিছু ক্যান লিস্ট শো করেছে
হ্যাঁ
13174 of 2012
yes, ma'am.
Kishore Raut versus Union of India.
Yes, on 14th, my lord, the matter was, my lord, in the list, my lord was.
One 1070 days. What is the original writ petition for?
Original writ petition for the writ petition for vending license, my lord, in the railway land, my lord. The license.
So how you have explained the delay?
My lord, the delay, my lord, explanation is, my lord, the matter was dismissed for default.
দেখুন না কি হলো কি ডিসপোজাবল নেই এখানে দিন আমায় দিন এটা আপনি দেখুন চেক করুন আপনি আমাকে তো শুনতে হবে Sir, in which paragraph you have stated about the delay?
My lord, the paragraph 6, my lord, the paragraph 5 and 6, my lord.
Kindly place. So you came to learn about the date of dismissal.
But date of and fourth my lord, the in 2024 25 my lord.
Huh?
2025.
Sir, place the relevant portion. I cannot find. On which day you come to know that your writ petition was dismissed for default?
25 page paragraph 5 my lord, on 21st April 2025, that is long after the COVID-19 pandemic situation was over, and requested his learned advocate to take steps for hearing of his pending writ application, since the respondent railway authority are taking steps to remove the said stallholders from the Chinchura station. After came to know the intention of the petitioner, his learned advocate instructed his clerk to serve notice upon the respondent for hearing. In obedience to the said instruction, before the service of notice for hearing, the said clerk obtained status report of the matter and came to know about the order of the Malad.
On which day?
Came to know about the
Sir, on which day you or your advocate's clerk came to learn about the actual date of dismissal?
21st April, my lord.
21st April, you contacted with your lawyer. So mechanically drafted.
Then
how do I calculate your actual delay?
On 21st, the delay, since 24th April 22 to the delay filing the restoration application is the 1070 days is the delay.
My clerk is here.
Asking whether there is any they have come, their application has come, and we are saying about some trust.
Trust.
Long trust is there.
Yes, my lord, that welfare trust is there.
What is the name of that trust?
My lord, he told me, my lord, he can inform us, my lord, within 5 to 10 minutes. But my lord, apart. Yes, yes. Yes, he is also the member of the Lockers Association. Welfare association, their fund is there. Yes, my lord, I shall inform you, my lord. My lord, regarding my lord restoration application, my lord, I want to say something. My lord. Your lordship, kindly see the paragraph 1 first. Any can, my lord. Kindly come to the condonation of delay, my lord, application. That challenging the purported disconnection of electricity and takeover position of vending stall run by the petitioners as Chinsura Railway Station.
Which paragraph, sir?
Paragraph 1, my lord.
Yes.
Paragraph 1 of the restoration application. The challenging the purported disconnection of electricity and takeover position of vending stall run by the petitioner at Chinsura Railway Station, even after accepting the license fees up to the month of May 2012. May 2012. Without considering the written representation by the concerned respondent, the writ petitioner applicant above named filed the writ petition before the Honorable High Court, Calcutta, being WP number such and such. And my lord, thereafter, my lord, the petitioner was evicted from the railway premises. And the stall has been completely.
Very good. That is not connected with the restoration.
Yes, my lord. Why, my lord? Thereafter, my lord, the several tender was issued for that platform number 1 and 2 and 2 and 3. And my lord, that tender was thereafter also, my lord, lapsed. Another tender was fresh tender. After 3 years, my lord, another tender was issued. So, my lord, what
third party interests have been created.
Yes.
Very good. Take this point at the time of
And
hearing.
my lord, kindly.
Take down. No, no, not now.
No, my lord, kindly consider this judgment, the Supreme Court judgment. My lord, what is the use of pending this writ petition, my lord? Kindly consider that.
Sir, if it is Mr. Ghosh, if it touches the merit, keep it with you and place this matter. If it touches with the merit of the instant true interlocutory application, then I can take up.
My lord, regarding the interlocutory application, I am submitting.
Yes.
Because my lord, after that, after filing of the writ petition, thereafter dismissal, and prior to that, my lord, he was evicted. That portion was, my lord, entirely demolished. New tender was
You are talking about the writ
No,
petition.
my lord,
Sorry. No.
My lord, kindly consider the judgment, the Supreme Court judgment. My
The
lord,
place, sir.
yes, my lord.
Who are
Paragraph 10.
obstructing you?
Paragraph 10, my lord.
Yes.
Paragraph 1987 Supreme Court 943, my lord. Paragraph 10. The High Court's order is not sustainable for yet another reasons. Respondents writ petitioners challenging the order of dismissal had finally disposed of on 10/8/1984. Thereafter, nothing remained pending before the Honorable High Court. No miscellaneous.
No, Mr. Ghosh. It is.
My lord,
It is
my lord, kindly see that.
No.
My lord, kindly see that 3 lines. My lord, kindly consider 3 lines. The High Court had no jurisdiction to entertain the application as no proceedings were pending before it. The High Court committed error in entertaining the respondent's application, which was founded on a separate cause of action. When proceedings stand terminated by the finally disposal of writ petition is not open to the court to reopen the proceedings by means of a miscellaneous application in respect of a matter which provided a fresh cause of action. My submission is this: there is a fresh cause of action. As soon as thereafter, when the fresh tender was issued, he ought to have participated that. He chose not to participate in the fresh tender.
Take this point at the time of hearing if the writ petition is at all restored.
And my lord, that
2000
That will be grateful, Your Lordship.
My lord, I appear for the petition. This is my restoration application, lordship. My lord, matter was dismissed for default on 30.
Within time.
My lord.
No, not within
No,
time,
not-
my lord,
my
there
lord,
is a delay.
During the COVID period, before prior.
What is the application for? It is a composite application.
And no delay application was filed.
My lord,
So what is the delay
my
application?
lord, immediately the COVID period was over. It was filed in the year 2022, lordship. On 27th April 2022, the application was filed, lordship.
Writ petition was dismissed in the year 2019.
Yes, lordship. Man, prior to COVID, lordship. That is why, lordship. Kindly see the order of dismissal. That is at page 8, page 9.
My lord has seen.
What is the writ petition for?
Well, application for compassionate appointment, lordship. Petitioner's mother used to work in the LIC, lordship. After her,
No, you file application for condonation of delay.
my lord,
Thereafter I shall
my lord,
consider.
my submission is lordship.
My lord,
See,
delay may be
my lord,
condoned and restored.
My lord, at that point of
Because
time,
he
lordship.
raised a point of the COVID
Ashok.
period.
Can 1 of 2022?
That.
This is an application for recalling of the
But I pay for the petition. My lord,
we have served. Now, my
What
lord,
are those cans?
my lord, first can, my lord, can 1 is my application for restoration. It was dismissed for default on 28th of April 2025. There is a, my lord, can 2 is my section 5 application, 65 days delay. And my lord, can 3 is, my lord, I was enjoying an interim order in the writ petition. Now, my lord, since the writ petition has been dismissed for default, the interim order, my lord, has been, my lord, vacated. Now, my lord, taking advantage of it, if your lordship takes up CRAN 3, annexure S3 at page 16. My lord, I have been issued a notice of vacation by the railways.
Notice of?
Vacation of the place over which I was enjoying an interim order. Kindly comes to annexure S3.
Which capacity you were
My lord,
occupying that?
my lord, we are, my lord, since 1981, my lord, we were paying rents, my lord, to the respondent railway authorities. Now, my lord, they were accepting it. An eviction proceeding was initiated. Eviction proceeding, my lord, an eviction order was passed.
By?
By, my lord, the railway authorities.
By the
Under the Public Premises Eviction of Unauthorized Occupants Act.
Challenging that you have filed
My
it?
lord, no, my challenging that we came up before my lord Justice Bhagavati Prasad Banerjee. My lord, there was an interim order. My lord Justice Bhagavati Prasad
The
Banerjee.
state officer's order is an appellable order.
My lord, at that time, my lord, the Honorable High Court entertained it in the year 1985. My lord, there was an order of stay. Now, my lord, thereafter, in 2003, we filed another writ petition. There was a direction that there is a provision under the Act to regularize, subject to payment of damage rent. We all along have been paying the damage rent. Thereafter, in 2004,
At the rate of?
well, at the rate of the existing rate, which was asked for by the railways, we are all along paying it. Well, at 2014, they issued an eviction notice. That eviction notice was stated by my Lord Justice Dr. Shambhuddha Chakraborty, my lord, as his lordship.
Eviction notice pursuant to the officer of the estate officer.
85 eviction order.
Naturally, it does not get time barred.
But they are keeping on renewing it, and this honorable court has time and again stayed it. If your lordship sees the order passed by my Lord Justice Shambhuddha Chakraborty.
So you are enjoying the order?
Yes. And paying rents. But there was a direction.
Paying rent at which rate?
At the existing rate, which is being assessed by
that I intend to know.
My lord, we are.
That I know. Very good. I am restoring it subject to payment of rupees 1 lakh.
My lord,
absolutely.
My lord, we are paying the damage rate.
I understand, sir.
My lord, we are paying the damage.
I understand, sir. I am allowing you.
But the railway is accepting it.
So what can be done?
No, my lord, that is the order by my lord Justice Shambhuddha Chakraborty. Kindly comes to annexure S1, page 12.
Very good, sir. You allow you.
My lord, kindly sees the condition.
No, it will be allowed, sir. Subject to payment of cost rupees 1 lakh.
My lord, kindly, my lord, he is a my lord. Kindly sees, my lord. My lord, there is a provision.
Public, you are depriving the authority from the public money, sir.
Our case in the writ petition is there is a provision for regularization.
Very good, sir.
And my lord, railways have regularized other persons.
What is the can 1?
My lord, can 1 is my application for restoration.
What is the limitation? Application?
CRAN 2.
Condonation of delay?
Can 2.
In which paragraph you have stated?
My lord, kindly comes to, my lord, paragraph 8 onwards. My lord, 28th of April 2025, it was dismissed for default, my lord. We did not have any knowledge. My lord, thereafter, my lord, we were served with the eviction notice. My lord, from the eviction notice, we gathered.
Shocked and surprised. Made and shocked and surprised to note the learned advocate had no knowledge with the order. Very good. Ashun. Can 2 of 2025.
True. But let it be 50, my lord. I shall come. Kindly.
1 lakh করে দিন।
দিদি কোথায় যাও মামা?
The application has been, which has been.
Well, I don't, where is the applicant?
I'm the
Can 1 and can 2.
Can 1 is required to be heard, my lord, on the basis of the.
What is can 2?
Can 2 an application for vacating of the interim order filed by the. It was to be heard, my lord, along with the main matter, writ petition.
my application, my lord. I am for the intervenant. Miss Chandal is appearing in this matter, my lord. She had to leave due to some medical emergency, my lord.
Not today.
Will you kindly make this not this week, my
Not this week. Very good.
Grateful.
Next.
Okay, my lord, the clerk will be very happy, my lord. All the clerk will be very happy.
Madam, actually.
My lord,
Yes.
my lord.
Yes. True, absolutely true.
Every successful lawyer, there must be
Absolutely, my lord. Absolutely.
Even our wives do not know, my lord, what we do in court or what things to be done. My clerk is known to
Actually,
everything. Yes, absolutely. Yes. Yes, absolutely. Without giving to any other, যাকে বাংলায় বলে তেলা মাথায় তেল. It is good. Grateful, my lord.
I'm for the respondent number 225. Most humbly, my lord, I beg to appear on behalf of the petitioner. My lord, this.
Same type of writ petition.
No, my lord.
It's different.
Lordship, this is, my lord, for an application for restoration of your lordship's order, my lord, for dismissal. My lord, the application was dismissed on 3rd July. My lord, this case pertains to, my lord, the petitioner is working in the Bank of India, my lord, an employee, my lord.
Can 1 of 2025?
Lordship.
This is an application. You are for Union of India.
No, my lord. I'm respondent number 225. Bank, my lord.
Where is the service?
Lordship.
Service has been affected, Mr. Rai.
Lordship, you answering, my lord, answering respondent is 2 to 5, my lord.
Huh?
Answering respondent is 2 to 5, my lord. And 2 to 5 has been.
No, you serve upon the respondent.
My lord, I have served, my lord, 2 to 5. My
Who are the 2 to
learned
5?
friend is appearing.
Bank, my lord.
Bank, my lord.
Respondent bank.
And he is the answering respondent, my lord. The main contention is, my lord, against, my lord, Bank of India, my lord. I have been terminated, my lord, on the allegation of misappropriation of funds, my lord. That we have challenged. One departmental proceeding has been initiated and I have been found guilty.
Then why you have made the Union of India party?
My lord, I have made a party, my lord, but usually, my lord, the answer.
What have you got to say with regard to can?
I have no objection.
Very good, sir. On perusal of the can
I am acting for the state, my lord.
Who is for the petitioner? দেখি দিন কেন কোন কি আছে দেখি।
Prerona Biswas.
You are for the
State.
you are
State, my lord.
both of you are for the state.
Yes, my lord.
Who is for the petitioner?
Petitioner absent, my lord. Prerona Biswas.
দেখি ফাইলটা দাও গো। Do you know what is
First-
can 1 of
first-
2025?
Can application is not filed, my lord.
What is
Can
that?
application file, first by can application file 17/1/2025.
What is the prayer?
Prayer is dismissed for default, my lord. That was dismissed for
Recalling of the
default
order.
and yes, my lord.
এই not to record রাখো, কেউ নেই বলছে এখন। আবার নাহলে ওটাকে
Second prayer,
AD 53.
Sir, do you know, it is not with your knowledge that whenever you appear before a high court, you have to button your coat.
I'm a applaud.
That minimum etiquette is expected to. What is your prayer?
Your Lordship, it was dismissed for default because my learned senior counsel was on her legs in some another court. She was when she knew that the matter has appeared.
last order, my lord, first 17/1/2005, my lord, first dismissed for default and next, my lord, 17/2/2005.
What is the repetition for?
Your Lordship, it's a land matter. There are some illegal encroaches on the petitioner's land.
It was dismissed for default on 13/2/2025.
Yes, Your Lordship.
It was again dismissed on 17/1/2025.
Yes, ma'am.
Huh?
And number
Oh,
was
no. It was corrected.
Your Lordship, the date was the writ petition number was not right in that order, so it was again in the list.
Ashun. Can 1 of 2025 is an application?
For the petition, Your Lordship.
Can one?
Yes, dismissed for default, Your Lordship. It is filed within time, Your Lordship.
2025. When it was filed?
No, 17th February.
18th April.
18th April.
17th February it was filed, Your Lordship.
17th February, my lord.
17th January filed.
17th January
The
dismissed
order,
for
ma'am.
default, Your Lordship.
Oh, I'm sorry.
17th February it was filed.
কি করে বুঝবো 17th ফাইল হচ্ছে?
Page number 10, Your Lordship. Affidavit page, Your Lordship will find.
The Zurat portion, ma'am.
The order is at page 11.
What is the read petition for?
Your Lordship.
What is the read petition for?
Your Lordship, it's an innocuous prayer, Your Lordship, as I may submit. Your Lordship, the petitioner has, this is the third round of litigation. An order has been passed by the competent authority. The petitioner only prays, let the arbitration application as annexed, Your Lordship, in page 83 to be considered by the arbitrator. Your petitioner's only prayer is, Your Lordship, page 83. There is a representation, Your Lordship, that is to be considered by the learned arbitrator. Page 83, Your Lordship.
Arbitrator will consider the representation.
Yes, under section 3G5, Your Lordship. 3G1 has been done. So under the National Highway Act, the arbitrator is competent to take application.
Who has approached the arbitrator?
My lord,
The petitioner has approached.
So he will act in terms of the Act of 1996. What is the
Yes,
scope for arbitration?
Yes.
The scope for representation.
He has never acted, Your Lordship. Kindly see when the representation is made. It's pending before the page is 24/4/2024.
No. If a reference is made to an arbitrator, arbitrator is bound to act under the arbitration constitution 1996.
Your Lordship,
What is the scope for considering the representation?
Your Lordship, the law act says either of the party can approach the arbitrator. So under section 3G5, either the parties are here, the National Highway or the petitioner both has the authority.
Yes, sir.
And under the provision of law to approach the arbitrator. We have approached the arbitrator on 24/4/2024. That is at page 83. Till now, he has not acted on that, Your Lordship. That representation before the arbitrator.
Page number?
Page 83. And it is in my prayer G as well, Your Lordship. Only the humble submission is let the arbitrator consider this in merit, but let the arbitration proceedings be started.
Ashun. Madam, disposing the writ.
My lord, only my lord kindly recorded without going into the merit of the matter, my lord.
Yes, of course.
The arbitration.
Can 1 of 2025 lekho. This is an application. This is an application for recalling the order of dismissal dated 17/1/2025. Stop para. By filing stop para. On careful consideration of the petition under consideration and after hearing the learned advocates for the contending parties, this court is satisfied that the writ petitioner has explained sufficient reason for his non-appearance on 17/1/2025 when WPA 19209 of 2024 was called for hearing. Stop para. Accordingly, prayer is allowed. Stop para. Consequently, the order dated 17/1/2025 as passed in WPA 19209 of 2024 is hereby recalled. Stop para. Consequently, WPA 19209 of 2024 is restored to its original filer number. Stop para. With the aforementioned observation, can 1 of 2025 is disposed of. Stop para. On WPA Teleco, on consent of both the parties, the instant repetition is taken up for hearing. Stop para. By filing the instant writ petition, the writ petition has prayed for issuance of appropriate writ of writs. Arbitrator has been made party.
Yes, Your Lordship. Respondent number 5.
Respondent number 5.
And prayer G is the prayer, Your
Prayer.
Lordship. Page A58, Your Lordship.
It's a prayer.
And page number 3, arbitrator is respondent number 5.
Kirilam. Who is the arbitrator? Under the National Highways Act 1956, hereinafter referred to as the said Act of 1956. Commanding him to act in terms of Section 3G, capital G within bracket 5 of the said Act of 1956. Stop para. At the time of hearing, learned advocate for the writ petition at the very outset draws attention of this court to page number 83 to 83 to 94 of the instant writ petition, being a copy of the letter dated 24/4/2024, as written by the director of the writ petitioner company, addressed to the respondent number 5 authority to conduct arbitration in accordance with the provision of Section 3G within bracket 3G within bracket 5 of the said Act 1956. It is submitted by an advocate for the writ petitioner that since the writ petitioner company was not satisfied with the quantum of compensation as has been determined by the CALA, that is the respondent number 6.
Respondent number 6, Your Lordship.
That is the respondent number 6 authority. The writ petitioner has invoked the provision of Section 3G within bracket 5 of the said Act of 1956, and the respondent number 5 authority, being the arbitrator, is duty bound to proceed with the arbitration for determination of the dispute. It is submitted that despite receipt of such letter dated 24/4/2024, the respondent number 5 authority had taken no steps to initiate a proceeding under Section 3G within bracket 5 of the said Act of 1956. Stop para. M.S. Rai, learned advocate, appearing on behalf of the NHAI authority, though disputed such contention of the learned advocate for the writ petitioner, however, it is submitted by her that the respondent number 5 authority, being an arbitrator, is duty bound to proceed with the arbitration under the aforementioned provision. Stop. In view of such, this court, while disposing the instant writ petition, directs the respondent number 5 authority to proceed with the in terms of the provision of Section 3G within bracket 5 of the said Act of 1956 on the basis of reference made to him by the writ petitioner under cover of its letter dated 24/4/2024. And to come to a logical conclusion of the same, positively within 180 working days from the date of communication of the server copy of this order. That is to say, the arbitration proceeding shall have to be completed by the respondent number 5 authority within 180 working days from the date of communication of this order. I am making it this more clear.
Yes, sir.
Chapter para. The time limit as fixed by this court is mandatory and peremptory. Stop para. Liberty is given to the learned advocate on record for the writ petitioner to communicate the server copy of this order to the respondent 5 authority. Stop para. The respondent 5 authority is directed to act on the basis of the server copy of this order. Stop para. Before parting with it is however made clear that while disposing the instant writ petition, this court has not gone into the merit of the arbitration proceeding as would be initiated by the respondent 5 authority. Stop para. With the aforementioned observation, WPA number 7.
No affidavit has been called for, my lord.
It is further made clear that since no affidavits have been called for, the allegations made in the instant writ petition are deemed to have been denied.
Deeply obliged.
With great pleasure.
About another writ petition. The
Yes, sir,
today
Mr. Chairman.
speaks for my lord
Yes, sir,
application for addition of party, my lord. ধর্মবতার আমি প্রতাপ বসু
আপনি দরখাস্ত করেছেন?
হ্যাঁ কেন পাঠিয়েছে আমাকে দিয়েছে addition of party
দিয়ে দিচ্ছি মানে আগে দেননি
কেন নেই কেন? আবার কি কথা? দেখুন ক্যান কোথায় আছে দেখুন বার করুন। Password for some time. They are searching for can. ওই আপনার অ্যাপ্লিকেশনটা খুঁজছে ওরা আছে দেখে।
even today my lord, here and now my lord, I got the copy of the application.
আগে দেননি?
আমি দিয়েছিলাম আমি অলরেডি মেলকে দিয়ে দিয়েছি আমি অলরেডি
সবাইকে দিতে হবে তো উঠে মহাশয়
ছিলেন না
নাই বা থাকলো তাকে ওগুলো চেম্বারে গিয়ে দিয়ে আসতে হবে তো।
আমি জানতাম না
এটা কি
What I'll do?
This is the report. Last occasion my learned junior was off sick, so she could not come. She tried to join through on video conferencing, but she could not. Now this is the report. অ্যাপ্লিকেশনটা কি ইন্টারভিউ মানে আপনি অ্যাড হতে চান কেন?
আমি তো কোনো দিকে
What is the writ petition for?
Writ petition kindly recollect in respect of my land. My lord, a notification under section 4 was published. Subsequent to that land.
Which order is under challenge?
Last page, my lord. Order dated 28 April 2025.
No, 26/2025.
No,
Come to prayer A,
yes.
page number 25.
Yes, my lord. Sorry, my 26/2025.
Where is that order?
182, page 182. My lord has heard at length, my lord, and my lord also seeks some report from the state authority. Perhaps today they are filing.
What order has been passed? What order has been passed?
Order, my lord, they are saying it is the land of the railway authority and directing me to vacate the premises, vacate the land within 15 days.
And kindly come to page 182, 183 and 184.
Last page is 184, my lord, that is.
It was under which act?
This is, they are saying, my lord, under the Land Acquisition Act, because, my lord, that land was, my lord, notification under section 4 was published of the Land Acquisition Act. Subsequently, that land was excluded in, my lord, section 6 notification. Thereafter, no proceeding. Thereafter,
Under which act?
Land Acquisition Act,
1894.
1894.
Huh.
They are saying, Railway Authority. Now, state has saying, my lord, in this report, which I want to file, my lord, exception to this report, that it was, my lord, acquired in under the Defense of India Act.
Huh.
So my contention is that, my lord, that is that act was, my lord, temporary in nature. So other plots of lands, which was, my lord, included in section 4 notification, was also, my lord, acquired under the Defense of India Act, under section 4.
Hmm.
Subsequently, those lands were, my lord, in the section 6 notification, and my land was excluded. So my
During the
condition,
publication of section 6 notification,
yes,
your land was excluded.
excluded.
Then,
my lord, there is no proceeding. When, my lord, I have got, my lord, mutation, I have got, my lord, sanction plan from the authority
so you
accordingly.
prayed for declaration that your land is not vested.
Yes, yes, yes.
তাহলে এই মামলায় আপনি কি করে পার্টি হতে
Oh,
চাইছেন?
my lord, is
আমি
that
party হতে চাইছি এটা অলরেডি ল্যান্ড অ্যাকুইজিশন থেকে যে ল্যান্ড যে অ্যাকুইজিশন হয়েছে সেখানে রিপোর্ট এখানে রয়েছে যে এই ল্যান্ডটা অ্যাকুইজিশনের মধ্যে
that
রয়েছে
court will determine what you?
ল্যান্ড অ্যাকুইজিশনের মধ্যে রয়েছে
হ্যাঁ।
এবং জেলা পরিষদ অলরেডি এটা স্টপ ওয়ার্ক নোটিশ করেছে জেলা পরিষদই
না
পারমিশন
আপনি এই মামলায় পার্টি হতে চাইছেন কেন?
মামলায় পার্টি হয়েছি 2013 সালে একটি পিটিশন করেছিলাম ডিভিশন বেঞ্চে সেখানে অলরেডি 19/4/2022 তারিখে চিফ জাস্টিস ওখানে নির্দেশ আছে আমি যেটা করেছি দেখুন পেজ নাম্বার
না এখানে রেলওয়ে অথরিটি বলেছেন রিট পিটিশনারকে আপনি চলে যান, এটা আমাদের জমি। রেলওয়ে অথরিটি রিট পিটিশনারকে বলেছে যে এই জমিটা হচ্ছে অ্যাকোয়ার্ড জমি, এটা রেলের জমি, আপনি এখানে অন্যায়ভাবে দখল করে আছেন, আপনি এখান থেকে উচ্ছেদ হন, আপনি এখান থেকে চলে যান। am I correct? স্যার am I correct?
Yes, yes, yes.
তাহলে আপনার কি ইন্টারেস্ট আছে এখানে?
আমি 2013 সালে যে মামলা করছি এখানে তো এই মামলার মধ্যে এখানে টোটাল উল্লেখ আছে এটা আপনার 22 আগস্ট 1961 সালে এই জমিগুলো অধিগ্রহণ করা সেখানে আমি যে দিয়েছি 39 নম্বর পেজে যে এটা রয়েছে টোটাল জমিগুলোই মানে সেলিং এবং আনঅথরাইজ কনস্ট্রাকশন কোনোভাবে হবে না এখানে চিফ জাস্টিসের এখানে নির্দেশ আছে
বেশ,
তো আমারই মামলা করা
তো আপনি এই মামলায় কেন পার্টি হতে চাইছেন সেটা বলুন।
মামলায় পার্টি হতে চাইছি কেননা আমি যখন 2017 সালে
আপনি কি চান ওদের উচ্ছেদ হোক?
হ্যাঁ একদম
হ্যাঁ
আমি আমি
স্যার প্লিজ
সর্বপ্রথম
হ্যাপেনিং ইন পারসন, আপনি চাইছেন ওদের উচ্ছেদ হোক?
একদম
আপনি কে?
2017 সালে এই জমিগুলো নিয়ে আমি বিভিন্ন জায়গায় আমি চিঠি করেছিলাম সেই পরিপ্রেক্ষিতে রাষ্ট্রপতি দপ্তর থেকে রেলওয়ে বোর্ড চেয়ারম্যানকে একটা নির্দেশ আছে
আমি বুঝতে পেরেছি, আমি আপনার কথা জানতে চাইছি যে আপনি আপনার সঙ্গে রিট পিটিশনারদের সম্পর্ক কি?
আমি এই সরকারি জমিগুলো বাঁচাবার জন্য তো আমি তো সর্বপ্রথম আমি
মানে আপনি একজন পাবলিক স্পিরিটেড পারসন।
হ্যাঁ 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 আমি সর্বপ্রথম এগুলো বছরে আনি
কিন্তু এটা জনস্বার্থ মামলা নয় যে মশাই, জনস্বার্থ মামলা এই কোর্টে হয় না। এই জমিতে কি আপনার কোনো ইন্টারেস্ট আছে? নেই তো। আপনার একমাত্র আগ্রহ হচ্ছে সরকারি জমিতে যেন কোন রকম ভাবেই কোনো লোক বেআইনি ভাবে থাকতে না চায়, এটাই তো বক্তব্য। কিন্তু এটার জন্য আপনি সঠিক কোর্টে আসেন, এটা এই কোর্ট সেই মামলাগুলো শুনছে না, বুঝতে পারলাম। আসুন can one
I have a case, my lord, where,
Who is this answering respondent?
my lord, I will answer because under Defense of India Act 1943 acquisition, requisition, thereafter the acquisition got completed as per my instruction, my lord, in 1943,
shall deal with it,
and
my lord.
they,
I know that, my lord,
they
when it was
accepted the compensation.
after expiry of the statute.
What do you want?
My lord, then I'll rely upon the report of the state government, my lord, because the state government will decide whether the land is of railways or.
না না
Done
ডিফেন্স অফ ইন্ডিয়া তোমার আইন
না এটা আমাদের রিপোর্ট আপনাদেরই ডকুমেন্টে রিপ্লাই করে আমরা
That is a completely different one. They have not placed before
My
them
lord,
on
then give me
authority.
1 week's time, my lord. Let me take instruction, my lord.
At this juncture, learned advocate appearing on behalf of the railway authority submits before this court that he also intends to file a report
My lord.
supported by affidavit.
My lord.
The report supported by affidavit is to be filed by the railway authority within 2 weeks hence. Exception if there are many is to be filed within 1 week thereafter. So we line to get it out. Let the matter be listed on September 2, 2025 under the heading fixed motion.
Kali, then my lord, extend the interim order.
Uh,
Your lordship, my lord, pass the interim order.
well, my report says acquisition is
No,
complete.
your report is not sacrosanct. I shall use the exception. Why you do? Last time, why did
Initially,
The interim order, as passed earlier, is extended till the last day of November 2025 or till further order, whichever is earlier.
I want to.
I beg to appear on behalf of the petitioner, my lord. Petitioner was an
Regarding item
employee.
number 56, my lord, yesterday matter was called on, and Mr. Piyush Kantira appeared on behalf of the respondent bank. And he faced for some time when my lord was reluctant to pass an order, and he lost the director, Mr. Rai, to appear someone for me, and I shall grant her.
So now you are appearing.
I'm not in the matter. Mr. Rai requested me, since my lord is directed to send on colleagues to put before this court or grant some time. Mr. Rai is not available in the court for personal debate.
On behalf of the respondent bank, an accommodation has been paid for. Prayer for accommodation is considered and allowed.
I'm praying for 2 weeks adjournment.
2 weeks, my lord, will not give. So somebody can have personal difficulty. I'm not objecting to that, but I was humbly praying for a short date.
Let the matter be listed on July 30, 2025 under the heading assignment.
There was direction in the writ petition to add Monglahat and Gajanan. The direction was passed by an order. It was taken before my Lord Justice Kaushik Chando. An order was passed that owners of the property, that is Monglahat Construction and Gajanans, are to be added. We understand, my lord, as of today, they have not added them.
There is no order, my lord, to our knowledge, my lord. This is my
No, there is
application for.
specific
Yes,
order.
Lord, maybe, my lord, I'm not aware of it. Lord, this is my application, my lord, for intervention. Lord, may I just place, my lord, there is another, my lord, order in respect of the same property, my lord. Lordship had already considered another writ petition, which is mine. And, my lord, there is an order subsisting in
My
that.
lord, the order is 13 September 2024
Two other matters.
by my Lord Justice Kaushik Chandra.
2 other repetitions are pending before your lordship. They are running under the motion.
আমি ওটা পরে 13 September 24, kindly have a look to this order. 13 September 24 by my Lord Justice Kaushik Chandra. দিয়ে দিচ্ছি ভাই, এক্ষুনি দিয়ে দিচ্ছি। হ্যাঁ,
হ্যাঁ ফাইলে পেয়ে যাবেন ওখানে there was specific order that they will petitioner shall add at the bottom your lordship will
appearing
find
on behalf of whom?
Mangla Hut construction
And who is Gajanan?
50% owners both of them are required to be
That
added
is under challenge.
Mangla
Suit is
Hut
pending before
Oh.
High Court as well as
Milord,
Howrah Court.
I am appearing for Mangla Hut Construction and Private Limited. There are two owners, Mangla Hut Company and Gajanan Company. By
They
this
have not
order,
been made party.
till now they have not officially made. No, in the writ petition I was not made party. While they moved it, by this order, my lord, they were directed to implead owners. As of today, they have not impleaded and given us copy in terms of this order. The order clearly records that the owners were not added as party. Petitioners are directed to add Mangla Hut
Lordship, will
Builders
kindly peruse the order. Milord, I have
Construction
handed
Private
over.
Limited and
Milord,
Gajanan. Bhai, ek second, no, no. Oh, sorry, my lord. Since the direction was there to add, they are duty bound to add.
I have heard.
I am sorry, my lord.
If you think that I have not
No,
heard,
I'm sorry.
I have not understood, you may speak in Bengali
Kindly
or
explain.
you may speak Hindi.
No, my lord, kindly
heard.
forgive me.
I am asking that question. What is the
There
predicament?
are two suits. Milord, I am for the intervener. This is my application.
Who is for the petitioner then?
Petitioner, Your Lordship, Mr. Shonak Bhattacharya is appearing in this.
Why have not added him party?
Take instruction, Mr. Shonak Bhattacharya is engaged in court number 40.
Not today, not today.
Here's the name of it. There was also direction to exchange affidavit.
We have already, KMD has already filed an affidavit.
And who is for the intervener?
Milord, I am for the intervener. Milord, I have handed over an order. Milord,
Your
passed
intervener
in the-
application has been allowed.
No, Milord, not yet. But before that, Milord,
That is
Lordship
scan
had-
one.
Yes, Lord, before that, Lordship had already taken up my writ petition filed by the intervener independently, Milord. That is, Milord, Milord, there is already an order subsisting in respect of that property, self-same suit property. And Milord, there is a dispute with regard to the ownership of the property and two suits, one in Howrah Court and one before the Honorable High Court at Calcutta is already pending.
I passed an interim order.
Yes, Milord, that is there.
In your writ petition, what will be a sought for?
Milord, it's the same. The state is claiming ownership over that property, saying that that is the state's property. And
What
in
is your
respect of-
prayer?
Milord, for setting.
Those rate petitions are pending
Are all
for
before your lordship.
43 and 45.
Is your prayer?
My prayer is for Milord setting aside of an order communication by which the state, Milord, the respondent authorities have Milord directed that, Milord intimated that that is the property of the state, Howrah Municipal Corporation.
Which you are disputing.
Yes.
And
Well,
what
they are
is the prayer in the writ petition? Do you know?
Advocate of record is also engaged.
That my prayer essentially is declaration that the respondent authorities do not have any right or interest over
Who is the writ petitioner here?
property.
Who is the writ petitioner here?
Let Basundhara.
Basundhara, represented by Mr. Sonak Bhattacharya. He is not here.
I know, sir.
I'm sorry.
I'm trying to understand the problem.
Yes, Milord.
His client, my lord, filed a
Setting
suit
aside.
challenging my deed.
I believe self-same order has been under challenge. Self-same order under challenge.
Similar, maybe, but not the same, but
Reading
the
the nature
actions are the
commanding
same.
the respondent authorities, thereby setting aside or maybe taken by behind the back of the petitioner for forceful possession of the marketplace. Mr. Bandhu, what is the prayer? What is your case? That you are the owner of the property.
No, I am the owner of the property. I am owner, my lord. I am owner of the property.
Why you want to take possession? That I intend to know. That I am saying. So it is according to the government land, and there are several claims over the properties. So both the petitions are required to be heard together.
Intercede dispute with regard to my ownership. His client, his client,
So
the
can it be
intervener's client-
decided in a rate petition?
No. Not in civil petition. His client, the intervening application is by a party who has filed a suit before this High Court claiming that he has an oral contract with him, with my vendors. By filing that suit, he has challenged my registered sale deed.
Oh, Mr. Bhattacharya has come.
There are orders.
My registered sale deed has been challenged by this intervening party. In that suit,
Either does it may both of you have challenged the decision of the state.
I will not appear in one matter, that is Bosundhara Housing Private Limited.
Huh.
One. Number that what is the challenge? There was a fire at Mongolahat. After that, that property, direction, we say that you cannot forcefully, the PWD started working there. We came up before this court. They disclosed, the honored advocate for the state and the PWD by way of affidavit disclosed that the property has already been vested with the state. Now, there are other writ petitions which have been filed.
So that vesting order is under challenge by both of you.
Exactly.
That I understood.
In other matters, my lord has already passed
interim order.
restraining the state.
So let both the writ petitions be heard together.
Exactly.
yes, but they should
And
comply with the
at
order
the same
dated
time,
September 24th.
Why not
Add Mongolahat and Gajanain as party.
Lordship will kindly, my lord,
That
also
order
allow
has
the
not been
application
complied.
Can
13 September
Can
24.
one may also be allowed, my lord, because I have an interesting party, my lord, interested
That
party.
needs to be heard. That needs to be heard.
Why putting their nose in my writ petition?
They could have made me a party. They did not. They know very well the suit, pending of the suits and the interstate disputes. Despite of that, they have not added me as a party.
That is some different dispute.
Yes, there are orders of injunction pending.
Injunction orders are there is special officer.
In this petition, there was direction for filing affidavits.
If both the writ petitions are taken up together, still you insist on addition of party?
As Millard, at least as a formality, because Millard, in this writ petition, Millard, because I have an interest in the writ petition.
I am the
That is what he says. That is what he says. Yes, without adding a party between the disputes between the parties, then he will.
ক্যানটা কোথায় গো ক্যানটা কোথায় কল্যাণ বাবু ক্যানটা কোথায় গো
Going there, disputed
Can
questions
one of
of
you
Millard,
doesn't
title pending, Millard, he would say that you are in dominant status and I will.
Can opposition দেয়া নেই তো কেন opposition দেয়া নেই তো হ্যাঁ
এমনি করে দেবে
ক্যানটা দাও হ্যাঁ বসুন্ধরা রিটে একটা ক্যান ফাইল করেছে নিমানি হ্যাঁ added respondent যাকে তুমি অ্যাডই করছো না despite direction I have not been added আমার উপর করছে না হ্যাঁ আর
What is the order under challenge?
Mr.
Bhattacharya, where is
no order under challenge. Milord, in there, kindly see the affidavit in opposition filed by the state.
Oh, filing করেনি and they are required to file reply. Order was passed directing read petitioner to file reply.
So what is the subject matter of challenge?
Subject matter of challenge, Milord, is that we filed a writ petition that we suddenly we found that Milord state is PWD has started working in the Milord in the heart. Now, Milord, we made Milord several representation. We made file RTI. We did not get any reply. Now, Milord, we filed the writ petition that how without acquisition, without vesting, our property can be taken over and Milord state can start development work. Now, Milord, after service of the writ petition, Milord, there was a direction for exchange of affidavits. In the affidavit in opposition filed by the state, they have for the first time declared, Milord, that there is an order of vesting. Milord, we are surprised without Milord giving notice. Milord, vesting has been done. One. Number two, kindly see the date of vesting. At a point of time.
I understand.
Like in my writ petition, Millard, there were also directions for filing reports, Millard, that we have not received.
আসেনি আমাদেরটা আসেনি এখন. It is only the writ of Basundhara is appearing.
All the matters, Millard, has to be tagged together and Millard hard.
So let them come, my lord, let them comply with direction passed on 13/9/24. And if it appears that all are similar, of course, all this can be heard. Yes.
Then who are Gopi Das Govardhan
These
sir?
are intervener who have filed the suit in original side.
The intervener and in WPA 6941
what-
we were the petitioners.
What right? Why you intend to implead as a party?
Milord, because I am, it is Milord, the dispute as to title, Milord, is already pending before the Honorable High Court. And Milord, it has yet to be decided whether Milord Gajanand is a owner of that property, because there is Milord, for setting aside of certain deeds, Milord, there are Milord prayers. So Milord, therefore, my title, Milord, the title
So
of
three
either,
persons are claiming that.
yes,
Three sets of persons are claiming that.
Independent writ petitions. If that
Your petitions are.
my petition is 6941 of 25. Milord, I have handed over an order.
Other than Bosundhara, there are 3 writ petitions.
And you are Mangla.
My lord, I am owner of the property Mangla Hut, and the other owner is Gajanand. Now, apart from, Are bhai, of course, allegedly, apart from these two owners who are owners by registered deeds, there are two other rival claimants who claims that my deed should be set aside and a decree to be granted on the basis of oral contract.
There is an order for adding.
For adding this, so I want them to comply, and they need to file a reply against affidavit in opposition. There was already a direction that the writ petitioner will file reply and the respondent will file opposition. Therefore, my lord, that direction needs to be adhered.
Look, they also have independent writ petitions, Milord Gajanand. Look, that is why it was.
Apart from this writ petition brought by Basundhara, my client Mangla Hut and Gajanan have filed two writ petitions in which we have, my lord, an order. Your lordship have passed an interim order in our favor. But this writ petition was taken up much prior to that on 13/9/24. This is at the instance of a party who claims an interest by an agreement. Subsequent to this agreement, the property stands transferred by a decree of this court in favor of my client. But whatsoever, I am not on title dispute. Once an agreement holder, these two are agreement holders. One says that I have a written agreement, the other says I have an oral agreement. Once, my lord, they file the writ petition on my property, they need to implead me. Therefore, on 13 September 24, upon hearing, direction was passed to implead those owners. So I want, my lord, let them.
And 1 of 2024.
Take grateful.
Whether
may I
they will
take
be
those file
disposed
and
of by a
do
common order or separate order, my lord will decide that.
If I can pass an order of tagging, I can pass an order for decagging also.
So for KMD is concerned, Miller, we have used one affidavit in Vasundhara. We will follow that.
All 4 matters will be taken up for consideration on 29th August.
So
ভুল যেন না হয় আবার এটা ওটা হয়ে গেলে গন্ডগোল হয়ে যাবে
all 4, 43, 45, 46 and 57.
I beg to appear for the petition in this matter. My lord, this matter has been assigned to your lordship, and it's the first day the matter is there, so I find my learned friend appearing for the state. He's not there. Mr. Wasim Ahmed, he had appeared in the court. It's assigned matter, 58 হ্যাঁ তো ওয়াসিম অ্যাপিয়ার করেছিল না আপনারা বলেন
This is an assigned matter. The writ petition is represented by his learned
My lord, this is my application.
I just put for 6 minutes.
Who's for the state?
For the state, Mr. Ravindra Narayan Dotto was supposed to
The
appear for
time
the
he's taking
state.
time on behalf of Rabindranath Dutta. Every day I'm coming and going. Last occasion also the same pair.
Don't give pain to Mr. Pan.
If they do have
By
seen me,
by
in the
adding
morning, they could have said me that I will
by
not.
adding only I in this Sunday match will not say allow. দেখি কি আছে ফাইলটা দিন তো।
The matter is going on. Whether the
Probably it is for the first time appearing before the court.
no, this is not
Huh?
for the first time.
আগে appear করেছে?
Yeah, earlier they appeared. They prayed for time. Last occasion, so they prayed for time on me, Mr. Dotto.
কিন্তু আমার কাছে appear করেছে কোথায়? ফার্স্ট টাইম করেছে।
No, no, no.
ফাইল দেখলে বুঝতে পারি ভাই।
এই কোর্টে আগে হয়নি তো।
জাস্টিস চ্যাটার্জির order।
মামলাটা ডেকেছে, তুমিও ছিলে না, এরাও ছিল। এই তো টাইম নিয়েছে।
The parties are represented by their respective counsels. On behalf of the respondent state, an accommodation has been paid for. Prayer for accommodation is considered and allowed as a last chance. Let the matter be adjourned for a week.
I am appearing online, my lord.
One minute.
On behalf of the respondents.
Who's for the petitioner, Mr. Lahiri?
Mr. Lahiri is there.
Yes, removal from service of a driver of SSB, সশস্ত্র সুরক্ষা বল. The allegation is unauthorized action.
You are appearing on behalf of?
Wala respondent. Wala senior counsel appearing on.
I am appearing.
Yes.
You are with him?
With my lord.
But the only
Mr.
allegation removal from service. And the allegation is unauthorized action. And yes, my lord. Readings are complete. Yes. And my lord. Yes, my lord. Yes, my lord. Before I place the matter on merit. No, my lord. I shall take some time.
Yes.
2 p.m. tomorrow.
Oh.
Oh.
Yes. Well, before I place the case on merits, I am drawing my lord's kind attention to
So it will continue till tomorrow.
Yes, yes.
I'm,
Give me a second, Mr. Lai.
drawing my lord's kind attention to the affidavit in opposition.
Give me a second, sir. Give me a second.
Well, let Mr. Laidi place the fact one by one. Directly to the affidavit in opposition, let him place the facts, my lord, first. Directly affidavit in opposition.
Maybe he has not a good case, which is why he has started with the
Well,
affidavit.
proportionality, disciplinary proceeding, he has challenged proportionality of the order.
Let my friend have his patience.
No, he says that when you have a good case, why are not start? Why are not making starting with the writ petition, but why you have started with the affidavit in
Opposition.
Because my lord, I am submitting this affidavit opposition is of no value, and it should not be taken any notice of. And I am making this submission relying on the observation of a division bench. Lordship, kindly see page 9 of their affidavit in opposition. There is no verification.
No, what is the case?
Yes, my case is this. My client, under compelling circumstances, remained absent.
Remain absent.
Remained absent. Well, while on duty, he met with an accident. For this accident, he was under treatment in hospital at Patna. But thereafter, he was given leave with medical pay. In the meantime, he heard his parents in Baruipur in South Chowbis Pargana fell very seriously ill. So he came. And
during the medical leave?
No. After
Yes.
completion of medical leave, he joined these duties.
Your client met with an accident?
Yes.
He was hospitalized?
Yes.
He went for medical leave?
Yes.
After recovery, he joined?
Joined.
Then what happened?
Then, my lord, he got the news that his parents in South Chowbis Pargana were seriously ill. So,
at that material time, he was posted at which place?
At that time,
Bihar?
No, in Bihar, Danapur.
So from Danapur, he came to Kolkata?
Kolkata, yes.
Without intimating the superior
Yes,
officer?
but after coming here, he informed his authorities and prayed for leave. And he does not know what is the fate of that application. And thereafter, he received a charge sheet on the allegation that you have remained unauthorized absent for such period. So, a developmental proceedings has been initiated and this charge sheet is issued to him.
How many charges have been framed against him?
Only 2 charges.
Very good. What are those charges?
Yes, madam. Kindly see for a moment. Detail. Madam, the memorandum is charged it at page 23 and actual P2.
Page number 23.
That is the memorandum of charge. That is 17th January 2005. And
memo of charge dated 17th February.
17th January
17-1.
Yes, madam.
17-1?
2005.
Give me a second, sir.
And madam, the charges are at page 25, Article 1 and Article 2.
The flag to दें तो भाई कोलन बाबू ये flag लो दिन खुल
number 25.
Page number 23 is the memo and page number 25 are the articles of charges. Mr. Laidi, place the articles of charges.
Yes. Article number 1. Whereas Sri Animesh Majumdar, driver, headquarter Patna, was advised 3 months rest by medical officer PMCH Patna owing to an injury she sustained while on government duty on 9/4/2003 at Patna. Sri Animas Majumdar, instead of following the advice of medical officer EMH Patna, left headquarters and remained absent unauthorizedly without proper permission and even without intimation from 10th April.
So on the following day of accident you went.
Yes. And
You suffered accident on 9th April.
April, yes, madam.
You have been advised to go for medical leave. And you on 10th April you went to your home without proper permission.
By the above fact, Sri Majumdar, driver thus has shown neglect of work or duty and found to be habitual absentee without permission and overstayed at his own will. He has failed to maintain devotion to duty and acted in a manner unbecoming of a government servant in violation of the such and such conduct rules. And then the article of Charge 2.
Yes.
The says Sri Animas Majumdar, driver, headquarters Patna, joined duty on 9/8/2004 after having absented from 10/4/2003 to 6/8/2004. Again, left headquarters without intimation and proper permission on 23rd August 2004.
Well, this will continue tomorrow. This will continue tomorrow. Well, audio is not there. Audio is not there.
Sorry, I'm sorry. Am I audible, sir?
Yes, yes. Good. But this will continue.
Tomorrow at 2 p.m.
Grateful, grateful.
এটা কালকে tomorrow 2 p.m. at the টপে রাখবে আপনি এই ফাইলটা আমার কাছে স্ট্রিক করে সাজিয়ে আমার কাছে পাঠিয়ে দিন আর তুমি আলাদা করে অর্ডারটা পাঠিয়ে দাও আর এইটা একটা আলাদা জায়গায় রাখো so that I can come ready also.
Fine, Lord.
Sorry.